Hello, welcome to the keynote speaker session at the LawWorks 2020 conference. My name's Joanne Sawyer. I'm Interim Deputy Chief Executive and Director of Programs at LawWorks. It's a real pleasure to be with you today. And to host this session, our keynote speaker is Andrea Coomber. She is currently Director of Justice, where she has been since February 2013. And prior to that, between 2002 and 2013, she was Equality Lawyer and then Legal Director at Interrights, which long title was the International Centre for the Legal Protection of Human Rights, where she and I, where I had the pleasure to work with Andrea, I hope it was reciprocal, to co-lead the legal team, where she was Legal Director and I was Litigation Director. And it's a real delight for me to be able to host her here in our new guises. At Interrights, Andrea did some brilliant work alongside leading the team, litigating cases before the European Court of Human Rights and the African Commission on Human and People's Rights, and trained lawyers, trained judges on international law and equality law across continents. Before joining Interrights, she worked at the International Service for Human Rights in Geneva and at the South Asia Documentation Centre in New Delhi, and she's qualified as a barrister and solicitor in Australia. Today, her topic is Justice at a Time of Crisis. And I'm really happy to hand over to her now. She's going to be speaking for about 25 minutes, and then we've got an opportunity for questions and answers and comments and discussion for another 20 minutes after that. If you have a question or a comment that you want to raise, please just indicate this by putting in the chat section the word question or comment, and we'll come to you later on. Thanks a lot, Andrea. I'm handing over to you now.
Great. Thank you, Jo. It's an enormous honour to have been asked to speak today. I'm particularly pleased to be speaking at the Clinics Conference because I've twice been a judge of the LawWorks Annual Awards over the last few years and have been left in awe at the incredible efforts being undertaken by clinics all over the country. You have my enormous thanks and respect for the work that you are undertaking. It's also lovely to share this virtual stage with Jo. As she's mentioned, I have the great privilege of being the 5th Director of Justice.
Oh, Andrea, you're now muted. Let's just...
Oh, sorry. For over 60 years has been Justice been working to strengthen the fair administration of justice in this country. By this country, I mean the United Kingdom. We're a cross-party charity. We work through and with our members to come up with practical evidence-based ideas for how to make the system better. We currently have got projects on benefits decision-making, on how inquests and inquiries procedures work in response to major disasters. And we're looking at racial disparity in the youth justice system. If you're not already a member, please make sure you do find out about our work and join our efforts. These are strange times. It's particularly odd for me. At the moment, my mum's quite sick, so I'm speaking to you from a hotel room in Perth, Western Australia, where I am living under guard for 2 weeks, courtesy of the government. And not for the first time this week, I've asked my 9-year-old son to lock himself in the bathroom with an iPad. If he makes an appearance in his underpants, I can only apologise. But we've been in here for 13 days and standards have slipped. It's happened a few times over the last 2 weeks. I've been asked to speak to you today about justice at a time of crisis. And I think when I was originally invited, the context was coronavirus. That was the crisis. And I will certainly talk about coronavirus in the framing of this speech. But since then, there's also been the killing of George Floyd. And I think it's necessary also to think about race in the justice system in the UK. So that's going to be my frame. And after consulting the ever-wise Robin Knowles, I've decided to talk about trust, which I think as lawyers is something we're used to talking about. And then I'm going to talk about courage. And at the end, I'm briefly going to talk about love, just to make you feel all uncomfortable, because lawyers never talk about love, and to evidence the fact that after 13 days in here, I really have lost it. I'm going to talk about access to justice, technology, diversity, and I'm going to talk about prison as various things. But I think fundamentally the last 12 weeks and then the last 3 weeks have exposed and exacerbated a crisis of trust. I'm not for a minute saying that we don't have a great justice system. There are things about it that are absolutely world-beating. As Jo's mentioned, for the 10 years before I joined Justice, I worked at Interrights, and one of the things I did was take cases to the European Court of Human Rights from Eastern European and former Soviet Union countries. In many of those countries, the rule of law was really weak and tangential to effective government. I remember once I was on a particularly depressing trip to Kyrgyzstan, where I was meant to be training lawyers on how to take cases to the individual cases to the UN Human Rights Committee. But actually it turned into a 3-day discussion about how much lawyers should be paying the judge in different courts in order to win the case, where that sweet spot was between making sure you'd win without having your client overpay. And in many places that Interrights worked, that's what justice was. Justice was a commodity to be bought and sold. And if you didn't pay the judge, you lost your case and you exhausted your domestic remedies, and you could take a case to the European Court of Human Rights or to the Human Rights Committee. Now, obviously, that isn't the case in the UK. It's one of the reasons why contracts from all over the world have clauses that they be resolved under English law, because people know that any subsequent litigation will be adjudicated by an independent, impartial court. This is a country in which you can judicially review a decision of government and stand a fair chance of winning. By international comparison, that is remarkable. I have friends in other parts of the world who think that's crazy, that can actually be a thing. The incorruptible nature of our judges and our lawyers, the fairness of our processes, set us up well for a system based on trust. But the truth is, we know that not everybody shares that trust, certainly not to the same degree. There are many people in our society who feel that the authorities, courts, lawyers, judges in that, are out to get them or have given up on them. And successive savage cuts to the Ministry of Justice's budgets over the last decade has done nothing for that trust. Legal aid has been slashed in amount and scope. Advice deserts have been created, which clinics, like many of the ones that you work at, are left to paper the gaps. As you well know, and you've been discussing today, the unmet legal needs of the nation's poor, but also of people of moderate means, has been increasing. Court buildings have been closed, courts with not enough court staff. Our judges have had to litigate in order to get the fair pay and pensions that they were originally contracted for. And that's all inadequate funding of a co-equal third branch of our government. And that is inevitably going to lead to an erosion of public trust. And we as lawyers, I think, have an obligation to do all we can to uphold and protect that rule of law, integrity of judiciary and public trust. It's only a couple of years ago that the Divisional Court in Miller was subject to vitriolic attack by elements of the press, with the then Lord Chancellor responding for days with shrieks of silence. Now the current Lord Chancellor has been very quick to defend decisions of the judges and judicial independence. And regardless of your politics, some of the proposals in the Conservative Party manifesto from last December, particularly around processes for appointing, confirming Supreme Court judges, rebalancing the relationship between Parliament and the courts, should give us all pause to think. And I think part of the problem is that for too long we think of the courts and the justice system as the domain of lawyers, in a bad year, fat cat lawyers. But the courts aren't about or for lawyers, much as they might be the workplace for many lawyers and judges. They're about and for normal people. And for years, Justice has been working to put the court users at the centre of proceedings. 2 years ago, we published a report called Understanding Court on how ordinary people experience court process. And it revealed pretty much what we already knew, which is that court is confusing and upsetting, intimidating for lay people, regardless of their role. And while that sense of isolation is increased for litigants in person, it's still the case for people who have lawyers. The dress, the rituals, the language, while they might add to the gravity and solemnity of court proceedings, they also scare and alienate ordinary people, and that erodes trust. The fact that so much of our justice system focuses on courts, I think, is a huge part of the problem. Too little of the system is about avoiding disputes We have an inadequate focus on public legal education, and people's problems have been left to fester and become legal problems, and then they enter the court system, a system which just isn't fit for purpose. And that's the way it's been for a long time now. It's certainly been like that for the whole time I've been at Justice, so 7 years. So our courts have already been in trouble, and then coronavirus has come along. And I don't think there's any doubt that government's response has diminished our trust in the institutions of government. You know, people have lost loved ones, their livelihoods, their education, their sense of safety. Women have died in their homes because they have nowhere to go because domestic violence shelters are closed or full. And we know that this virus, this particular virus, is especially fatal for people who are sick, for people who are old, or for people from certain ethnic groups. And the measures sort of imposed to respond have also disproportionately affected those people, poor people, marginalised people, vulnerable people. A few weeks ago, my son and I were walking our dog in King's Cross and bumped into a boy from his class who's 9, like Henry, and has got 9 younger brothers and sisters who all live with their parents in a 2-bedroom council flat. And his mum was beside herself. They were already struggling, and she was describing the kind of pressure on their family, their finances, their housing, their mental health, their fears for the future. And that would be common to so many of you through your work in the clinics. But these are the people who've really had had their lives really affected and suffer through this process. Now, the good news is that much of the justice system was pretty nimble in response. And the courts and tribunals in the UK were quicker to keep up, particularly in England and Wales, quicker to keep up and keep working than pretty much anywhere in the world. The ongoing reform programme, which had already seen an investment in technology and in the piloting of various remote and virtual proceedings, were able to go live pretty quickly. Some bits, for example, the Supreme Court or the Property and Business Courts, adapted very swiftly. Lord Kerr, the day after lockdown was announced, delivered a judgment virtually from his home in Tonnockmore in Northern Ireland. The reform-minded leadership of the Chancellor of the High Court meant that it was possible for Chancery in commercial cases to continue. The commercial bar did not take very long to realise that they needed to quickly get on board with new ways of working in their slippers. And both of those jurisdictions were well placed. The parties were well represented, they were IT savvy, they didn't involve vulnerable people, they aren't reliant on much or any in-person evidence. In other courts, there's been a much more mixed picture. Some family, civil, administrative court proceedings have continued virtually. Many of the tribunals have moved online very swiftly. I've come straight from a steering group meeting from the Administrative Justice Council, which Justice chairs, but is chaired by the Senior President of Tribunals, Sir Ernest Ryder, who was talking about how some of his tribunals have actually managed to deal with their backlog through this process because their new ways of working have been so efficient and have actually not seen a diminution in applicant success rates. So that applicants appealing government decision-making have continued to succeed against government at exactly the same rates, which is encouraging. I'll come back to crime in a little bit, but that crime has been worst hit because of the suspension of jury trial, and we've only had a handful of socially distanced jury trials held over the last 3 weeks. Obviously the pandemic's forced the system to go digital at an extreme pace, and the systems may have worked, but they haven't always worked for the people using them. We've been concerned for a long time about digital exclusion. I see that Amanda Finlay's just popped up. She chaired a working party for us a few years ago on digital exclusion. And that's been particularly heightened in this unusual environment. A lot of the recommendations that Amanda and the working party made in that report simply aren't feasible in a socially locked down, distant society. So people who would normally have been able to get help from a family member have been unable to see their relatives. People who normally go to McDonald's to use free internet haven't had that option available to them. The social distancing measures have actually compounded lack of access, I think. And as lockdown measures ease, hopefully greater support will be available, but it remains a problem. On the plus side, government has, HMCTS has redoubled its efforts to capture information about what's happening, and we've got a huge opportunity now to understand much more empirically about what works and what doesn't, and what we can learn to build a better justice system. There are some excellent projects underway to understand how the pandemic has affected different individual settings. Natalie Byram's work for the Civil Justice Council and court response civil courts, PLP's work on judicial review. And we need to use this time to build, I think, an evidence base. And but throughout all our concern for access to justice, for the last 6 years, Justice has been calling for more of dragging courts into the 21st century. So for us, the pandemic is unlocking some of the keys for greater access to justice in the future, things that would have taken much longer had we not had this particular moment. The Lord Chief Justice has repeatedly said that the courts can't go back to normal at the end of this period. We don't yet know which bits of that he means we'll keep and which bits we'll return to, and I'd be interested to hear what you think about that. I expect we'll see a maintenance of virtual for lots of preliminary hearings, for example, which have seemed to work pretty well and for which there's been professional response. But there's no doubt that while digital has allowed us to keep operating, it's made it in still a restricted way. So the number of cases reaching court has plummeted, buildings are closed, people working from home. As ever, the people who most feel that justice is unavailable to them are those already most marginalised in society. And there's going to be a backlog created and prediction of new cases flooding in once we pass lockdown. And we need to think about whether the system's robust enough to deal with that, whether we'll be in a position to regain trust. I think only time will tell. But I want to move from trust as a problem to courage as a solution. And I think as difficult as the current climate is, and as discombobulating as it is, it's not the time to be trapped in the headlights. It's the time to seize opportunities, to reimagine processes, to innovate. Unfortunately, lawyers aren't great with change, but we need to make justice much less about how we've always done things and returning to that, and much more about what works better. It's funny, when we did our report on understanding courts a few years ago, everything we came up against was, that court was confusing and upsetting. Everyone I talked to in the system already knew that. And they just accepted it as acceptable cost of adversarial justice. And I wonder when as a society we become more and more conscious of mental health, whether we'll start to wonder why it's okay that teenagers are cross-examined in family courts or in criminal proceedings, or their evidence is being tested by them being accused of lying by silks, by clever counsel trying to trick women into slipping up on dates when they allege that they were raped. I mean, is that really going to be acceptable? I wonder. I suspect that over time we will think it's less acceptable. But on courage, I want to talk about one thing that we've done. So on the 23rd of March, the Lord Chief suspended jury trial. And we at Justice decided that we'd hold a test of a virtual jury trial. We did it because we were concerned that the social distancing requirements over time would mean that pressure would be put on the feasibility of juries as a thing. And as Justice has supported jury trial for 60 years, that seemed important to us. There are huge numbers of prisoners on remanded to custody. That's increased over the pandemic. And numbers of victims waiting to have their day in court. And it didn't seem to us that endless adjournment would be consistent with fairness. So it had never been done anywhere in the world before. We contacted an IT company that had already had some contracts with HMCTS and volunteers, and went around designing how a virtual jury trial would look, how it would work. We asked for volunteers from our membership to serve as jurors and witnesses, and we arranged for 2 barristers we knew, both deeply sceptical, to be our prosecutor and defence counsel, and we found a retired Crown Court judge to be our judge. Someone else played the defendant, and we asked 2 academics from Oxford who specialise in fair trial and court spaces to evaluate the trial for us. And at the time of the first trial, I was so convinced it was going to be a disaster that I didn't tell anybody. I didn't tell any of my friends on the bench, in the court service, in the profession. I didn't want to waste anybody's time. So we held our first trial and I watched from the public gallery. And much to my surprise, it wasn't a disaster at all. The tech failed a couple of times. There are a few aspects of it we needed tweaking, but fundamentally it worked. And the judge and the sceptical barristers reported back that they felt it was a real trial. They could assess the evidence. They were able to lead and cross-examine the evidence. The witnesses, they could put forward their case. They connected with the jury. And the evaluators found the same thing. It had worked. And so over the last 10 weeks, we've held 3 further trials, each time improving the platform. And because there were concerns about jurors being at home, last Friday we held a trial with a jury in a socially distanced space within walking distance from their home, which met Public Health England's guidelines. And they had headphones and headdress screens prepared for them. And they went into a hall and they engaged on the virtual platform and deliberated in the virtual space. And we also, for last Friday, had a defendant who was on a real video link from Leeds Prison, HMP Leeds, and a court clerk and bailiff from the court service. And again, the evaluation and feedback has been overwhelmingly positive. So I suggest you check it out on our website. Now, you might ask what this has got to do with courage. Well, because while these 4 trials were just ours, like a little justice, it's a small charity trying to find ways to keep juries going, the efforts were met with masses of derision and abuse from certain elements of the profession. The criminal bar sent around one particular missive that angrily, in all caps, declared that virtual jury trial was a fantasy. A number of prominent Twitterers said they couldn't believe that we would dare explore something so dangerous and damaging as a virtual trial, that we were uncaring of defendants' rights, when actually the evaluation found that defendants' rights were being upheld better in a virtual space. And we had such criticism, I mean, real bullying from certain people, and some of them important people, that we were even exploring this at a time that they, frankly, were proposing no solutions whatsoever. For every angry tweet or ill-informed blog post, I received at least a couple of emails from members of the criminal bar and former judges who'd watched it, who'd read the evaluation report, and who were full of praise and encouragement for our efforts. Encouragement, French for giving hearts. And on Monday night this week, the Lord Chief Justice suggested that he supports dispensing the jury trial altogether for either way offences, having people tried by judge and 2 magistrates instead. And hopefully the criminal bar will be now changing its tune. But without our preparedness to innovate, we'd be left with no feasible alternative but to get rid of juries. It's only one example. Over the years, Justice and others have done lots to strengthen the system that's required: piloting, testing, going through collaborative processes to find out what's worked. I've been really impressed, and I encourage you to look it up, by the recent pilot undertaken by Law for Life and the Resolution, which provides fixed costs, unbundled legal advice for people navigating their way through family breakdown. Like everything that Law for Life does, it's in plain language, absolute clarity around process, and critically cost. And you can find it on the Advice Now website, with which I'm sure you're all familiar. But there are other examples of how innovation is necessary, and none is without its detractors. We do have that old sort of maxim of necessity is the mother of invention. I think this is a period for unlocking that curiosity. We need to see what works. We need to challenge ourselves to think about things differently. Why are we opposed to flexible operating hours? Why have we been opposed to video hearings over time? I have to say one of my great disappointments of this period has been the unwillingness of the Ministry of Justice to seriously explore alternatives to custody. Despite the vulnerability of prisoners and the immense responsibility of the state for their well-being, to last week, only 81 prisoners had been released during this period of coronavirus: 55 early release, 21 pregnant women, 5 compassionate grounds. This would have been the perfect opportunity to look at alternatives to custody, particularly for vulnerable people. Instead, prisoners across the country are locked up 22.5 hours a day without visitors, and we have, I think, lost an opportunity. Moving beyond the virus, I think we also need to have a serious look at our laws and institutions in our justice system, and consider the possibility, explore the probability that they don't operate in a neutral fashion or always provide equal justice. You just have to look at the number of Black children in the youth justice system, overrepresentation of BAME people in the prison population. It's difficult to conclude that the system is fair. And that crisis of trust, I think, is exacerbated by the reluctance of many in the profession to acknowledge and seek correction of those shortcomings. My concern is that we, as a profession, have become pretty comfortably adjusted to injustice. And that requires white people, myself included, to overcome what I think is sort of a guilty shame that some of us feel when we look at the legal system, and be willing to talk about race. When the Sentencing Council told us in January that Black and Asian men were more likely than white men to go to jail for Class B drugs offences, and that Asian men would be sentenced for longer spells in prison, we need to consider the possibility that the system may somehow be operating to privilege people of a particular race. And I'm not suggesting that that's intentional, but it is a system that it's a possibility that we do have to consider. So, I mean, I think we do have to know that these sort of things are changing. Our profession is overwhelmingly at the senior echelons, overwhelmingly white. We do a lot of work at Justice on judicial diversity and diversity in the professions. And we know that while there are BAME partners of law firms, there are very few BAME silks, very few senior judges who are Black or Asian. Just as there have, I mean, it's true there've never been more. We've got more now than ever before, but the rate of change is far too slow. I mean, that in 2020, our highest court in the country comprises of 12 men, all of them white and only 2 of them women, should really worry us all. The pipeline for the Supreme Court is 1 Asian Law Justice of Appeal and 3 Asian High Court judges out of 108. And Linda Dobbs, appointed before the JAC was set up, is the only Black person ever to have served at a high court level. And these are the most powerful courts in the country. They adjudicate citizens' relationship with government, our rights. They can take away people's children, their liberty. They can do everything. And the fact that they are overwhelmingly white, mostly male, mostly privately educated, should be of good concern to us. And we can't pretend it doesn't harm the public trust in our justice system. And the route to the bench obviously starts in the profession. Ensuring diverse cohorts of students are offered opportunities to get training contracts, pupillage, entry positions at places like Justice, that progression to senior ranks of the profession is open to everybody really fairly, that people don't have to put up with microaggressions or snide comments. We have to recognise that life is different in the profession, in our profession, for people from racial minorities. I spoke at a Criminal Justice Alliance event last week, and the observations of some of the people about their lives at the bar before they went to the CPS was shocking. It wasn't shocking, I wasn't surprised at all. I've heard it all before, but it is in no way acceptable. So we have to challenge ourselves and have to be prepared to be uncomfortable, and we have to be prepared to change things. So that requires courage, I think. So trust, courage. Finally, my final idea to demonstrate my breakdown, which is love. So at the end of last year, I watched a lecture by the US philosopher and preacher Cornel West. And at one stage, he commented that in private, love is tenderness and intimacy, but justice is what love looks like when it goes out in public. And I've been thinking about it a lot. So for the last few years, I've taught students on the Learning Together course up at a Category C prison in Suffolk called HMP Warren Hill. The Butler Law course is privately funded by the quite remarkable president of the Law Society, Simon Davis, and it brings Cambridge law students together with inmates from Warren Hill to learn about law, not just law students, just students. And it was set up and run by my friend, Jack Merritt, who was killed 7 months ago now at London Bridge. Now, most of the students are Black and Asian. They're approaching the end of long sentences. A number of them are in for joint enterprise murder, even though they never picked up a knife or a weapon in their lives. Pretty much all of them were excluded from school. And it's only in prison that they've become interested in learning or realize that they're not stupid. And all of them have had limited opportunities when they're younger and then taken some very bad decisions for which they've been in prison, some of them for 20 years. And working with them and teaching them and learning from them has been one of the most inspiring and life-enhancing things I've ever done. I've learned patience and responsibility. I've learned about regret. And Jack absolutely loved those men. And I find myself thinking about him and his work, and therefore my work there, as sort of a love in action. And I think, you know, what is justice as a concept if it's not fairness and dignity and respect and trust? As people who work and run clinics with vulnerable people at their lowest moments, I don't have to tell you that much of law, or much of what we do in law is not what we learn at law school. It's about listening and empathy and asking timely questions and giving people time to respond. And as much as I don't expect you to ever phrase it in these terms, in my view, it's an act of love. I think it's important to look around through and beyond this crisis and to find and to seize those opportunities. And judges and lawyers are doing that every day, making a small difference through small acts of kindness and care. You know, judges in the family courts who explain rulings to children so they can understand why they're living with mum rather than dad. Criminal judges looking in the face of hardened, addicted people who are incorrigible and exercising mercy. And lawyers who gently tell, you know, look gently and care when a woman tells her details of a relationship deteriorating into violence. It's these small acts of kindness and respect and fairness that I think demonstrate love. And like your work in clinics, I think one by one, with a bit of courage, they all do their little bit to rebuild trust in the justice system in this age of crisis. That's all I have to say, except for all the questions.